Morning has broken, my windows are open. Wanna feel the wind blow through my hair. Which way do I follow? What happens tomorrow? I turn to you and hope you can guide the way. Sometimes I give up, just wanna be on my own. Even in the darkest times, you give me hope. So I lean on you when I've lost my way. I keep holding on for a better day. I lean on you when the world's astray. I left my heart open so you hear my prayer. I left my heart open so you hear my prayer. In times that are changing and when hope is fading, I know I can turn to your embrace. 'Cause there's so much beauty under your heaven, and I'm grateful every day. Sometimes I give up, just wanna be on my own. Even in the darkest times, you give me hope. So I lean on you when I've lost my way. I keep holding on for a better day. I lean on you when the world's astray. I left my heart open so you hear my prayer. I left my heart open so you hear my prayer. I lean on you and I lost my way. I keep holding on for a better day. I lean on you when the world's astray. I left my heart open so you hear my prayer. I left my heart open so you hear my prayer.
Hello, everyone. First of all, I want to say thanks to Allie and Michelle for being on panel with me.
Thanks for
Hello,
having me, Chris.
Steph. Hello, Jack. Oh, thank you, Allie, for being here. So we've got a lot to go over tonight. Hello, Lori. Tonight we are going to be going over my uncle's case. It's going to be two parts of it. The first part is motions made for evidence, because I think that's very important, and the opening statements. Now, my uncle's name was Otis Randall Abner. And everybody, if you don't care, give me some hearts in chat for my uncle and his daughter. His name is Otis Randall Abner. And on September the 10th of 1987, he went on to a cemetery with 3 other people. Now, 3 people came off that cemetery, and only one was tried for his murder. We all know where I stand with this. I think personally they all should have been tried. But that is my opinion, and I'll let you all decide, because you'll get to see the court documents for yourself on what you think. Hello, James. Okay, Allie, Michelle, do either one of you want to say anything before we get started?
I appreciate all of you for being here to hear about this case. It's very important for everybody to know the corruption that has went on in Kentucky and with Crystal's family.
Yes, I agree.
Absolutely. Hello, Catering Rich. Okay, I'm going to share my screen and we're going to start. I was going to start with jury selection, but there's a lot that needs redacted on that. So we're just going to jump right in. And if you all have anything that you want to add, just interrupt me. And Lori, if you have anything that you want to add, just put it in chat, honey. You know you're always welcome up here.
Okay.
I'm going to read the court. Allie's going to read Mr. Robinson, which was Marlo Brock's attorney, and Michelle is going to read Mr. Bingham's. Those whose names were not called may have a seat momentarily in the back area. The remaining jurors was excused. Now, you all have been selected by both sides to hear the evidence in this case. And you will hear the evidence and be called upon when it's all over with to decide, render a verdict as to the guilt or innocence of the person charged here. It will be upon you to listen carefully to all the evidence that's given, because if you don't listen and you don't know what's been said, you will have a difficult ever deciding. And you should decide it strictly upon the evidence be fair with everybody, and one main thing that you seek for all during this trial will be the truth. You all are the judges of who is telling the truth and who is not telling the truth. That's up to you to decide what weight to give any witness that testifies. You seek out and try to find out what the truth of the whole matter is, and then it's not hard to decide from there on out. We're not having any court this afternoon. I guess it's my fault because I have to go to a dentist this afternoon to get a tooth fixed. And when you have a bad tooth, I'm sorry, but when you have a bad trouble with a tooth, you can't do anything else. And we'll come back tomorrow morning at 9:30 and you'll hear the evidence in this case. And we'll hopefully might get through tomorrow. If you don't, we'll finish it up Friday. You all think that we can finish it up in one day, and I'm going to stop right there. If you have a case for capital murder, one day,
No, you're not going to get it done in one day.
No, that's unheard
no,
of.
that's bullcrap is exactly what that is. That's trying to rush a trial, and it should have never started out with like that. But I mean,
Exactly.
they just got the jury picked, and here they are already one day. Do you think that we can get it done in one day?
I'm really not sure. We don't really know the length. We'll be finished tomorrow or we'll go into Friday, Your Honor.
I'd say it'll be Friday, Judge.
We'll probably be here Friday also. We'll come back tomorrow morning at 9:30. Okay. Now, jury released to return July the 14th, 1988. Witnesses recognized to appear. And it says that they paused for unrelated matter. I have no clue what that unrelated matter was. We're on record now in the case of Commonwealth of Kentucky versus Marlo Brock. We had to take care of some other matters that were already set for today, continue them and set another day. We'll not get to them today. And before we get into hearing evidence in this, I have to pass on a number of motions that the defendant has in this case. complete the record on it, and you all may relax and be around here where we can get a hold of you in the courtroom here or out in the hallway there temporarily. We'll be maybe about 30 minutes, I would say. We'll be in there hearing motions. We'll get out as quickly as we can because we want to get this case started and completed as soon as reasonably can do so. And again, he's talking about just wanting to get it over with, in my opinion.
Yeah.
I agree.
And some of this, the court reporter has missed words, so bear with us as we try to read it. Motions in chambers. Mr. Robinson, you may present your motion.
Judge, the first motion concerns lab results on a shirt of Marlowe's, and the motion is, comes the defendant by counsel, and moves this court to suppress the use of the lab analysis and results of the defendant's shirt that was seized by the state trooper McKnight. And the grounds for this motion are that the state police obtained a brown short sleeve shirt from the front seat of the defendant's car. That shirt was submitted to the state police lab for testing to determine if any substances were on the shirt. The report that I obtained from the Commonwealth showed that what was found on the shirt, they were not able to determine the type blood because of insufficient amounts. From the report, they were not even able, as far as I could tell, to determine whether or not it was human blood or other blood. For that reason, I think to introduce the results of that test would be extremely prejudicial to the defendant while having really no probative value. Because we don't know what kind of blood or whose blood, if it was human blood that was found on the shirt. So for that reason, I'd like to have the shirt suppressed, the results.
What have you got to say about it?
Comes now the Commonwealth in response to defendant's motion to suppress in this matter and states its objection to the motion, and in support of its objection would state that even though the blood could not be typed and could not be specifically identified to the defendant, that can be well covered in cross-examination. What was taken from the shirt, and there's testimony that he wore that shirt that day, and I think the defendant's attorney can very well bring out that they can't type the blood or, can't specifically show that it was Mr. Brock's. On the lab analysis, it doesn't state that she could not show that it's human blood.
Let's see what the lab analysis says.
Right above it there, Your Honor, she had typed some blood. I believe from a beer can on there that states it's human blood. But there's no statement in particular as to the t-shirt. That doesn't mean that she can't specifically say that it was human blood. I don't think there's anything there that the defense counsel cannot sufficiently cross-examine.
Is this, we're talking about this t-shirt?
Yes, sir, if you can decipher the results.
What would be your ideal of exhibiting it before a jury if you can't show that it was human blood or a certain type or his type or what?
Well, she doesn't say on there that she can't say it's human blood, for one thing, Your Honor.
Doesn't say that it is either. Says trace amount exhibit 2. Trace amounts of blood too limited for further analysis as found on exhibit 3, which is the shirt. Exhibit 3 just says it's blood.
Well, Your Honor, he did have that shirt on, or that shirt on the date that the murder occurred. That would give some sort of inference.
Well, if you could show that he had the shirt on,
I mean, the jury is capable of deciphering that, if they want to believe it or not. That's just one of the things in the surroundings.
well, I know they wouldn't have to believe any of it as far as that's concerned, or they could believe it. And this is blurry, and it was actually blurry on the page, so I will read all of it to the best of my knowledge. Or they could believe all, but, and then it says Mr. Robinson. But the problem I have, the court, unless you've got something basic for exhibiting something, a basis of connecting it with that person, a trace amount of blood, that's pretty far off unless you can go a little further with it. I'll not rule on it right now, but I'll see what is said on it, and I may rule it out, and I may not. Mr. Bingham. The loud people, I think all of them are supposed to be here a little later. The court. Bring that up when it's Mr. Robinson. Well, Judge, the only thing I would ask that is that the Commonwealth not mention the shirt in opening arguments or anything prior to this. The court. Well, they can, Mr. Robinson, or mention any results of the testing. The court. They can exhibit the shirt if they can prove that it was his shirt, Mr. Robinson. The shirt is fine, but
What I have a problem with is the lab results.
but don't mention any blood on it until there's further testimony on it. Just don't mention the blood. You might mention the shirt. Clothing is always permissible in a case of homicide or any other case, but you have to connect it with but you're putting on a chemical analysis, an expert to testify, and I don't know. They haven't stated here that was his blood. They haven't stated it was human blood as far as that's concerned.
Right. And I think that would be prejudicial.
And it could very well be. I don't want to make a mistake in it. Okay, now what's your other one? Okay, first of all, I got something to say before we start on this. We read the other day their own testimony, and several people saw Marlowe that day. I personally do not see what the problem with presenting this shirt would have been, because, for instance, if they had not seen him with blood on his shirt earlier in the day, and say the last people that saw him before he went to Uncle Ball's didn't see him with blood on his shirt, then that would kind of prove a timeline, in my opinion, of when he got blood on his shirt.
Right.
Right. Well,
I mean, chat if you agree.
I mean, like Arctic says, he understands wanting it to be thrown out. And I understand the defense attorney doing his job.
Right.
It's his job to try to limit as much evidence as he can in the trial. It just doesn't seem to me like the Commonwealth put up much of a fight. That's where the problem lies with me.
Yes.
Yeah.
He's very lackadaisical about it.
I definitely think that the Commonwealth dropped the ball in this case completely. They botched this case. As we saw in the last episode, they were still investigating during the grand jury. They should have had all that done. So I completely agree.
Absolutely.
And Lori says that's exactly right. And Lori, if you at any point want to correct anything that these people say, you go right ahead, or if you want a link, let me know. I'll send you one. But his daughter is in chat, you all. Please put hearts in the chat and keep her in your thoughts and prayers. This has to be hard on her. I know it is. It's hard on me. I know it's hard on her. Okay, Allie.
This concerns the photographs that the state trooper took of the scene, and I would, at this time, comes the Commonwealth and moves, comes the defense and moves this court to suppress the use of the photographs taken and asks that they not be allowed to be presented before the jury. The reason that we're asking this is that the photographs only show what will already come out in other testimony, that the defendant was shot and that he was found in a car at the scene. The only purpose the Commonwealth would have in showing them would be really to inflame the jury and to prejudice the defendant. As I stated, that anything that the pictures will show will be brought out in other testimony. So I think they'd be cumulative and not necessary and would really just prejudice the defendant without having any probative value.
Okay, and Michelle earlier when we were talking about this, she made a very good point with this. Let's imagine that somebody got hit by a car and they were put in a wheelchair. Are you going to keep the wheelchair out of the courtroom? No. Just so that the jury isn't prejudiced towards them? So really, what is the difference? But
There isn't any.
I don't see a difference.
let's see what you've got there.
Do you just want to see the ones of the victim?
I want to see the ones he's objecting to.
Whatever ones you're intending to.
I don't want to see that whole stack there.
Whatever ones you're intending to show to the jury.
And this is Trooper McKnight, which before I even read his statement, I would ask you all. They are in the judge's chambers talking about this. The lawyers and the judge. Trooper McKnight is a witness in this case. What is he doing back here?
That's a very good question.
Yep.
Okay, these three of that particular, there could be more, but I've not had a chance to go through them. But those three are three that I had picked of the scene as I saw it that night.
Okay, hang on. Does that mean that the trooper is deciding which pictures are submitted into court?
Yes.
And not the attorney?
Exactly.
Okay. These three, Judge, on behalf of the Commonwealth and in response to Mr. Robinson's motion, there might be testimony as to the victim, but the pictures depict exactly where the victim was positioned, where the victim was shot, the type of shot he received. Trooper McKnight will testify as to the type of weapon he at the time believed was used, and later came out that it was typed, and we do have testimony as to what type of shotgun was used. As far as in response to Mr. Robinson's argument that it would inflame the jury, I mean, this is a murder case where a man had been shot in the head with a shotgun. I think the jury is entitled to see exactly what we're dealing with in this particular situation.
But Judge, I mean, the basis of my argument in response to the Commonwealth's response is that they will be able to present and will present any testimony concerning the scene through various witnesses. And the only real reason that they would be presenting these pictures and want these before the jury is to show how gruesome it was and to try to inflame the jury, really, because they are particularly nasty pictures. There's no doubt about it.
It's a nasty crime, in my opinion. That's Crystal, not the court. What does Lawson say about it? Now, I have no clue
Probably a
who's
lot.
Lawson is yet.
Right. Yeah.
No, I don't either.
Who is Lawson?
Probably a lot.
Hopefully. Well, you could probably pick out a couple of them to show the condition there and where the deceased was in the car and something like that. Now, these two here, I would rule admissible. I wouldn't go on and on with a lot of the others just to impress that on the minds of the jury. Generally, a photograph is admissible into evidence if it fairly and accurately represents what it purports to show. You've got to show that, number one, by someone who took it or saw it. Changing of the condition between the time of an incident and taking of the photograph will preclude introduction of the photograph if the change is significant to the purpose to which the evidence is offered. It would be offered, I presume, to depict the conditions of where the deceased was, his position in the car, and that I'm going to permit that.
Judge, then are they going to be limited to these two photographs that?
Well, I've indicated that they probably would be, unless
Okay, and no other?
there's something else they want to show. There's no use in going on and on and on all photographs you might have. But to show where the body was, to show the car and whatnot, it's really not to show that the man is dead. You can prove that by other things.
Judge, one thing in this case, and the one reason that these, as far as the location of the body, may become particularly important for one thing, is if Mr. Robinson decides that the other individual who was up there outside of the car, if part of his defense will be to say that the individual committed the murder, his mother was sitting in the car next to this gentleman, 17-year-old boy.
Is that person a witness? The one that was sitting in there?
I don't know that he's going to do it, but that...
Have you got a picture of that? And then Trooper McKnight, we have a picture, Your Honor, of where the witness was sitting in the car at the time of the incident. We have a picture of where her shoes were. She was on the passenger side of the front. We have a picture of the passenger side of the front showing her shoes. Again, and this is just my opinion, with a little bit of common sense added to it, a pair of shoes sitting in the floorboard of a car does not prove somebody was sitting there.
That's right.
Okay.
No.
The court. Will she testify that she was sitting there?
Oh, yeah, but...
And were her shoes and whatnot? Yes, sir, she will. Seems he knows OG awful good.
He does, doesn't he?
Well, it might be permissible when she testifies to that fact and could ask her if she recognizes that photograph.
Well, what I was saying, though, I mean, this is speculation. I don't know what Mr. Robinson will bring up, but I think it would be something that would be argued to a jury that a 17-year-old boy would not shoot a shotgun into a car at this particular situation with his mother sitting there.
Well, you could still have that argument whether you had a picture or not. If she testified, she was in there.
Yeah, that's true. But I think this would depict where the gun came from and the danger he would have put his mother in.
Well, we'll take that one up when she testifies. If you have one to introduce, then I'll pass on it then. You'll probably object to it, but I'll pass on it. See the something of it. I can't pronounce that. Sorry. Competency
Yes, sir.
of it.
Yeah, competency. Yes, sir.
Okay, I'm going to look at chat for just a second because I know I've missed a lot. Why wouldn't the jury get to see how horrific? Arctic, that is a very good question. Exactly, Rhiannon. Rhiannon. Okay. Okay, what else have you got?
Judge, at this time, I have a motion having to do with some physical evidence, the shotgun which is sitting over there. Comes the defendant by counsel and moves this court to suppress the introduction into evidence or the mentioning to the jury of the shotgun obtained by State Trooper McKnight as grounds for this motion. The defendant states the proper chain of custody to establish that the shotgun obtained by Mr. McKnight is the same shotgun that was allegedly found behind where the defendant was residing, is not going to be able to be established unless they are prepared to bring every person in who has had custody of the shotgun from the time it was found in the brush pile until it's introduced into evidence today. I think there's probably some evidence that, the reason for that is that the shotgun had the potential to have been tampered with at various times along the way. Mr. McKnight obtained the shotgun from Tennessee. Defendant obviously lives in Knox County here today. It changed hands several times.
Can you connect that shotgun with the defendant?
Yes, Your Honor. We can positively connect it with the defendant or connect it in such a manner that will satisfy the chain of custody.
Judge, what I'm stating is I don't think that they can present every person who has had physical possession of the gun from the time it was found until.
I think, Your Honor.
Until the time Trooper McKnight came in possession.
Under the rules of chain of custody, I believe we can identify it by the individual who Mr. Brock obtained the gun from, which would, as far as being the actual gun, would.
It's a completely different matter.
I think we can bring around the chain of custody by showing that Mr. Brock, or the individual who owned the gun that Mr. Brock took it from, can identify it that it was his gun.
That is the same gun that he sold?
Judge,
that was taken. It wasn't sold, Your Honor.
Judge, I consider that. I think that's a different matter. The gun was allegedly found in a brush pile behind the defendant's house. At that time, it was changed hands several times and ended up in Tennessee. It had the potential and may have been cleaned or altered during the time it was in different people's hands, which could affect the lab results that were done on it and other things. For that reason, I think it should be suppressed.
What other thing other than just the gun is about it?
Well, we have shells that was found at the same.
A hole, yes.
There was one hole at the scene that
Can you show that it was fired from that gun?
we have an expert that will come that is going to say that it was definitely fired from that gun.
Well, I don't know right now. I'll pass on that one whenever it comes up. When he gets into his how he got it, where it's been since then.
Judge, in that case, I'd like to ask that it not be mentioned to the jury in opening argument, or any time prior to that, or any time prior to his testimony concerning the gun.
I think that he could make in an open statement that he has the gun that we intend to show. And of course, if he failed to show it, then it wouldn't be introduced as evidence. But I think your intentions are to an open statement is what you intend to prove. Sometimes you can prove that, sometimes you can't. And I think it would be permissible for him to state that you intend to introduce a gun that was allegedly used in this case.
What I would ask is that they not go into details as to either where it was found or how it was found or how they obtained it.
No, they wouldn't be any use of that in opening statement at all. An opening statement is just to generally give the jury a preamble of what's going to happen, what evidence you probably will hear. You don't know what witnesses are going to testify. You can say the defendant is going to deny shooting him, and he could get on the stand and admit it. And maybe you wouldn't even know until that happened. But that's just what you expect. You expect to do. That's what an opening statement is, that you expect to prove so and so. Okay, what else have you got, Mr. Robinson? So, right there, you all. They're trying to get rid of the gun. They don't want the gun put in as evidence. So far, we've already seen they didn't want Marlowe's shirt that had blood on it put in as evidence. Now they're trying to get rid of the gun, which ultimately, as you all have seen already, they made a motion to destroy the gun after the second trial.
Right.
Okay.
Right. Your Honor, the Commonwealth has subpoenaed the defendant's wife to testify for the Commonwealth in this case. She is intending to assert her privilege of not testifying either for or against the defendant in this case. So I'd like to ask that she not even be allowed to be called, because just the fact of her being called and her being made to assert her privilege out there would prejudice the defendant when all she's doing is asserting her right.
What is the latest law on that?
I think that there's a statute.
You cannot force, they can if they want to.
It's the wife's decision, the spouse's decision, but she's already asserted that she does not want to testify. We can have her come in and she can put it on the record if you'd like.
She has that privilege, but she can, if she wants to, testify.
Right.
I think we need to put it on the record whether or not she wants to or not.
Have her come in here. What's her name?
Edith Brock.
Sorry.
That's okay.
I did that before.
I know, Lori. It does mine too. It breaks my heart, and it breaks my heart for you, honey. I love you, sis. Now, your name is Edith Brock. Michelle, be the witness.
Okay. Yes, sir.
Are you the wife of the defendant, Marlo Brock?
Yes.
You have been subpoenaed here as a witness for the Commonwealth. I can inform you that you do not have to testify anything against your husband. You all are still living together, not divorced.
No.
And right there, that could go either way.
Yeah, it could.
I mean, that could be they are not living together. So why is there so much assumption? Why didn't he make her clarify this right here? Anyways.
Right.
I see them do that a lot.
And yes, they do that a lot in here. And there's inaudible a lot when they need to say speak up so the court reporter can record what you're saying. But they don't do that. Not here in Knox County anyway. I guess they just don't want to go by the rules.
Well, if the court reporter can't hear them, I have serious doubts about the jury being able to hear them.
Exactly. And you have the privilege of not testifying against your husband. Okay. If you so desire, you can testify if you want to. What is your desire?
I don't want to.
You don't want to testify? And look
Jake
at this.
said no.
Now, whenever would that be allowed in another case?
It's not.
Never.
Nope.
God, it pisses me off. Anyway.
The court
Okay.
reporter has to be able to hear it to record it, report it.
Exactly. Exactly.
Report a head shake.
Right. Yeah,
She's not supposed to anyway.
exactly.
Nope. Okay. Do you want to ask her anything?
No, Your Honor.
You know, my good question is, why in the world subpoena her anyway?
Well, that is a good question.
I mean, right here, no, Your Honor, I would ask, are you afraid of him?
Well,
You know,
absolutely.
never know what she's going to say.
That's right.
Oh, anyways. Okay, the motion will be sustained on that.
Thank you, Your Honor. Judge, there's one last matter. Mr. Brock filed a pro se motion.
Yeah, I looked that over. It's in the file.
And I'd like to have your ruling on that.
It's in the file. I've read it over and I see nothing in it that would be grounds for the dismissal of this indictment. So that will be overruled.
I think the second part of his motion had to do with the PFO count of the indictment as being contrary to the language of the statute of the U.S. Constitution.
Okay, put a 1 in chat if you need to know what PFO stands for. Because I'll tell you, it's persistent felony offender. I looked it up. Okay. Well, we can take that up if there is a conviction in this.
When we get to that point,
When we get to that point, and if you have anything to present to the court on it, we'll consider that at that time. If he's not convicted in this, the PFO would have nothing to do with it. Do you have anything else?
no, sir.
Judge, if I may, on the gun, bring it back up at this time and ask the court if we could try to take some testimony or something on the gun, because I feel like we would need to mention it in opening argument in order to show how the Commonwealth thinks we have a case.
Well, I don't see anything you'd have to do other than that you intend to produce for this jury part of the evidence, the gun.
Well, we intend to show that part of the motivation was that Mr. Brock went to his pot patch and discovered that it had been stolen and came back to this boy's house who owned the gun, mad, and stating that the victim had stolen his pot patch. A few minutes later, his gun was missing. It's the gun that shot the victim, and it turned up 125 feet from where Mr. Brock was asleep.
Have you got witnesses that he went to this place with the intention of not audible?
With the intention of what?
You said he went to this place.
He was at this particular boy's residence, and they were shooting the weapon, and he, the defendant, and another individual, which is going to be a witness, left to go check their pot plants that morning, and they came back to the same place where they had been firing the gun, and the defendant testimony will be that he was extremely mad, stating that the victim had stolen his pot plants, and they went into the house. And there's testimony as to sort of how this all came about. He left the house for about 15 minutes, got the gun where the boy who owned it had put it, and then left real quickly. And the boy went immediately to see if the gun was there, and it was gone. And it ends up, it's the same gun that shot the victim, and it's the same gun that was found. $125 or 100 and some feet, 123 feet from where the defendant was sleeping. The same boy that was with him will testify that he did have the gun at the scene. So you see, it's
This gun.
this gun. So I think it's crucial.
Well, you could. That would all be competent evidence if it's brought about right. And you could say what you expect to prove.
Judge, could I say one more thing if I could?
Yeah.
The problem we have with the introduction of the shotgun, period, is that I don't think that they can show that the same people had the shotgun, or that the shotgun was not altered in any way, or that it was not cleaned. It has changed hands several times, and I don't think they can bring in the people to show that the shotgun was not altered or changed. I think that each person that handled the shotgun or had possession of the shotgun should be required to be here. Otherwise, they shouldn't be allowed to introduce it or mention how the police came in contact with it. Now, whether or not the testimony is to whether it was at the scene of the crime, that's a different matter. They can testify that there was a shotgun at the scene of the crime, and they can testify that the person's name where the shotgun was allegedly obtained was Jesse Smith. They can talk about Jesse Smith having the shotgun. What I'm having problems with is Commonwealth introducing the shotgun as evidence, because I don't think they can show that. It had the opportunity to be altered and changed from the time the police came, from the time it was found to the time the police came into contact with it.
You don't?
It's like a blood.
Question the idea that they can introduce evidence that there was a shotgun?
That part's fine. What I'm having a problem with, it's like the blood sample. If a blood sample was taken,
In other words, it's this particular shotgun.
Yes, sir. It's like a blood sample or something like that. If blood is taken from someone, you have to bring in each person that had to show that it wasn't changed or altered, or it's the same blood. I think they should have to show that also for the shotgun, this shotgun.
It is not good. I've had that experience in trials to exhibit around. An exhibit of what? I recall one particular incident where the prosecutor had a crowbar, exhibited it to the jury all through it, and he told me he was going to file as evidence. When we got down to it, he didn't. He couldn't. And I thought it was highly unethical.
I think so too.
And it was. And I got on the attorney about it. If you get it there, it's been seen, showing it to the jury, and then knowing that he could not connect the crowbar with the crime he was talking about. And that was a big.
Well, it's not our intention to march around the courtroom and try to make a spectacle with it. It's just, we can show.
Well, I don't expect you to do it, and I wouldn't let you do it.
We can show a great relationship there. Putting the defendant in the position.
You just.
Judge, this is like a blood sample that's taken from the defendant or the victim or anyone else. Once it's taken from them, each person that handles the blood has to be recorded. They take it to that person, and that person signs for it, and the next person signs for it. I think that should have had to have been done with the gun from the time it was found allegedly in the brush pile to the time it was going to be introduced into evidence to the time Trooper McKnight came in contact with it. I think each person should be required to be here and testify to that fact, or it shouldn't be allowed to be even discussed, that particular shotgun.
Judge.
He can talk about, I wish he would complete his sentences. I'm just going to pause and say that because my goodness. He can talk about, that he was killed. You can show that he was killed by a shotgun. I presume you can. That you have a shotgun. Now, let's don't exhibit that gun until I determine whether or not it can be exhibited in evidence. I would not attempt to prevent you from saying that if you can show that he was killed with, and if you can show that this defendant had a shotgun or evidence that would tend to show that he had a shotgun and the type of gun that he had and all that. But as far as exhibiting the particular gun, as far as exhibiting that particular gun there, I want to wait to see what the evidence is, whether or not it can be filed as an exhibit in this case. But we're not going to hinder you in any way from talking about it. But I don't want you to get up there like this instance I was telling you about and take that gun and say, now, here is the gun that shot this man, until
Personally, I don't want to handle the gun.
Until it's filed as an exhibit.
That's fine.
Now, when it's filed as an exhibit, you can do that.
Judge, what?
And to file as an exhibit, you have to prove the authenticity of it. That is the same gun they had. But you can talk about a gun because he was killed with a gun. And you, from what I've heard here, you can have evidence to show that he had in his possession a shotgun. And that's not going to hinder you any. But I just don't want you to exhibit this particular gun until I pass on this. And I want to hear some more on it.
And what goes along with that is they shouldn't be allowed to discuss where this gun was allegedly found or any of the chain of custody from the time it was.
They could discuss even if it was never filed into evidence that they found a shotgun at a particular place, and that if they can show that the one they found was in the possession, if somebody knows of the defendant, the only thing in proving the chain of custody of it would be for this particular weapon, for them to file this as an exhibit in this case.
Judge, the individual that was with the defendant at the time of the murder saw the gun there. He was also with him at the time the defendant took the gun from the house. And they, got it at the point he had shot it with the defendant prior to that. And he has ID'd the gun since.
Well, I want to hear some evidence on that before I pass on it. I might be wrong anyhow, but I could be a way off to do it now. One way or the other, I don't know exactly what's going to be testified to yet. What else you got?
I'm trying to. Understand, exactly where I stand now. Can I, in opening testimony, tell you what I think?
I thought I made it plain. I do not want you to exhibit this particular gun until it's filed in evidence. I think that's right. You both understand that. When it's filed in evidence, you can exhibit it. But until then, I do not want it exhibited. Now, you can talk about a shotgun, that you believe you could show that he was killed by a shotgun. You believe that you could show that he had in his possession a shotgun. You couldn't show the jury, I don't suppose, that he was killed by that particular shotgun. You have no ballistics or anything on a shotgun, can you?
Well, the lab man says we have the test, the lab technician that's coming that will state that
the pellets that came out of that gun went into the man?
He can't show that. They came out of that particular shotgun. But
And then Trooper McKnight, he speaks up again. The lab technician says the pellets are consistent.
That's you, Crystal.
I'm having a problem here. Why is this man back in the judge's chamber when he is a witness? He is a witness in this case. He was the trooper that they called, not, just nonchalantly call the dispatch and then he gets dispatched out. No, they call him personally. So why is he back there in the judge's chamber helping them make these motions?
That's right.
If one witness cannot hear another witness testify, then what gives him the right to be back there? He's a witness.
yeah, I'd love to know if that's ever done anywhere else.
Yeah.
I remember the officer saying they could match the hull to that particular gun. And there you have it. Okay. Yeah, they pretty much say that here in so many words. There's just one problem. It's a shotgun. And the way I'm understanding, if it's birdshot, it's hard to match to any shotgun, correct, Michelle?
Usually with a shotgun, it's the barrel that puts an imprint on the shell. But if it's a sawed-off shotgun, there's no barrel to put an imprint on the shell.
Right.
That's what I understood.
Yes,
Cherokee
Lori, I
girl's
agree.
still in here. She's pretty well versed on that. She could tell us.
Okay. Well, they could say there's consistent, yes, but they're not like a pistol or a rifle. They can't say that that is the gun. Nobody, I don't suppose, can say, yes, this is the gun that killed this man. Not on a shotgun, no, sir. But you talk about a gun. I'm just talking about exhibiting this particular gun. Until I determine whether or not it can be filed as an exhibit, a visual exhibit, that doesn't bar you from introducing your evidence of a shotgun. But I don't want you to exhibit it until it's qualified or the chain of custody has been followed. But even if I did rule that you couldn't file that into evidence, would not bar you from showing all the evidence you had that the man was killed with a shotgun, that the defendant had a shotgun, and that you could even describe the gun. I'd like to know where my uncle's gun is. I know how my daddy was. He didn't leave home without his. He slept with it under his pillow. Lori, was Uncle Ball the same way? Of it and whatnot.
Judge.
But we get into a different field when we say this is the gun that killed him and exhibit it, letting the jury see a weapon that you don't know whether it was used or not.
Judge, before they're allowed to testify to any lab results that were done on this gun, will you require that the proper chain of custody to be established?
Okay, and in chat, Lori says, nor did my dad. So Uncle Ball didn't leave home without his weapon either. Yes.
So they cannot testify as to any lab results done on that gun.
Yeah. And if they don't, of course, they'll have to show the parties the gun in the witness stand, which is all right. But if they don't establish the chain of custody properly, well, I'll instruct the jury that they would not consider that particular gun because it was not properly identified. But that doesn't bar you from showing the shotgun.
And talking about the shotgun.
You understand that now?
Yeah, I'm clear now.
Okay, so it says end of suppression hearing in open court. The court. Ladies and gentlemen, this took longer than necessary, but I'll assure you, we were working on some problems in this case all the time we were back there. So I'm sorry you had to wait, but it's one of the things you have to bear, I reckon, by being on a jury. But will not waste any more time than is absolutely necessary for you. At the bench, out of the hearing of the jury.
I just want to make sure about the separation of the witnesses.
Yes. Now, the rule has been asked upon the witnesses. Now, when the rule is required, the witnesses have to vacate the courtroom. They cannot hear any evidence and then later testify. So if you are a witness, again, Mr. McKnight was back in the judge's chamber anyway.
Mm-hmm.
For the defendant or a witness for the Commonwealth, you cannot testify if you hear other witnesses testify. So you will have to now vacate the room. And if you're seen in here during the process of hearing evidence, why you will be barred from testifying. So any witness now, the Commonwealth witness, be out there where you can find them. We've got a room for them. Now, defendant witnesses will not need them until later, maybe this afternoon.
May I
Later
check
this
on one
afternoon.
witness?
Yeah.
Is Jesse Smith here? J.C. Smith.
Witness answers present. The Commonwealth attorney will now read the indictment. The clerk, Judge, I need to swear the jury to try the case. That's right. The jury hasn't been sworn yet. The clerk reminds me of that. You will now be administered the oath. Okay, the Commonwealth attorney will read the indictment and may make a statement about the case if he desires. Now, you all, it's scrolling across the bottom of the screen, but I'm putting a trigger warning out there. Please protect your own mental health. This is not for anybody 18 or under. Okay.
Thank you, Your Honor. Mr. Robinson, ladies and gentlemen of the jury, again, my name is Kim Bingham, and I'm here on behalf of the Commonwealth today. And I would, at this time, read the indictment handed down by the grand jury. The grand jury charges that on or about the 10th day of September 1987 in Knox County, Kentucky, and within 12 months from the finding of this indictment, the above-named defendant committed the offense of murder by shooting Otis Randall Abner with a shotgun. Ladies and gentlemen, on behalf of the Commonwealth, I am here today to show you the evidence that we have in this case. And at this time, I'd like to tell you what we intend to prove during the course of this trial. The main thing that we intend to show is that the defendant, Marlo Brock, did murder the victim, Otis Abner. We are going to call several witnesses in support of our position. And we feel like that once you've heard the evidence, that there will be no doubt in your mind that the defendant is guilty of murder. One of the most precious things that we have in this world is life. And when someone kills another individual, the law deals a stiff punishment. As a matter of fact, it's one of the worst crimes, if not the worst crime, that can be committed, is to kill somebody. Regardless of who that person is, nobody has the right to go around killing someone else.
Mr. Robinson, buddy, he's talking to Mr. Bingham. You're getting into argument of your case. Let's confine it to opening statement of what you expect to prove. You can bring your arguments on later.
Shouldn't the other attorney have objected?
You would think.
And
I don't
also,
think the judge had the right to say anything until that happened.
Right.
He shouldn't have. But also, I want everybody to notice at the bottom of the screen, this is page 64. When I took the photographs of these documents, I went in order. I made sure I did not miss a page. I want you to notice what it does, because there's 2 pages missing. And that's
I
just
apologize.
this far.
Yeah. I apologize, Your Honor. The Commonwealth will show, or we intend to prove, that on September 10th, 1987, that the defendant, Marlo Brock, committed murder on Otis Randall Abner. There's several actors that are important in this case. One actor is Jean Crawford. Miss Crawford dated the
And now it's going to skip 2 pages, but boy, did they get that right. She's an actor and a half. That's
Yes.
my opinion. See,
Mhm.
it skips to 66, from 64 to 66. So I'd like to know what happened to those other 2 pages.
Yeah.
What
But
was in them?
it says dated Marlo Brock, if you went in order.
Marlo Brock told Jesse to fix them some breakfast. Jesse started fixing them some breakfast. Mr. Brock excused himself, went outside, stayed about 15 minutes, came back in and told Jeff that, let's go, we'll go to Druthers and get something to eat. Jesse will tell you that he realized that Mr. Marlo Brock was mad, and he went straight out to where he kept his shotgun, and it was gone. The evidence will show that later in the day, or closer to nightfall, that Jeff and Marlo went to Jeff's mother's house, Jean, and Jean was there, and the victim was there. Otis, or Jean, will tell you that she was in bed, and she heard Jeff and Marlo and the victim talking about some pot plants, and that the defendant told them that he knew where somewhere at that they could go steal. The evidence will show that the victim got Jean Crawford up out of bed, and that Jean and the victim got in one car. The defendant and Jeff Crawford got in another car. Now the victim and Mrs. Crawford followed the defendant to a cemetery. The cemetery is located on Hammonds Fork Road. When they got up there, they were sitting at the cemetery, and Jean Crawford will tell you that a few minutes later, she heard a shot and felt something on her. She looked over at the victim and he had been shot. The evidence will show that Jeff Crawford was there and that the defendant had a sawed-off shotgun. The evidence will show that at that time, Mrs. Crawford and Jeff and the defendant got in the car and went to Mrs. Crawford's other son's home, Robert. The evidence will show that they went inside the house, and Robert will tell you that his mother was covered with blood and that they were tore up, and that Jeff was extremely upset that the defendant, Marlo Brock, tried to borrow some money. And when he told him he didn't have any, the defendant left, and that Jeff told his brother Robert what had happened, that Marlo Brock had killed Otis Abner. The testimony will show that right after that, Mr. Crawford went to the residence of Chuck Johnson, who lives right down the road from him, to use his telephone, and they called the Kentucky State Police. In particular, they called Trooper McKnight. Trooper McKnight came along with another state trooper. They went to the cemetery and investigated the case and found the victim dead at the scene. And from all the evidence pointed that he had been shot in the head at close range by a sawed-off double-barrel shotgun. Later, Trooper McKnight went to the home of Robert Crawford and talked with Jean Crawford and Jeff Crawford. And then later, from the testimony that you'll hear, he had cause to arrest Marlo Brock for the murder. The evidence will further show that right after Mr. Brock was arrested, that a young boy found a double-barrel sawed-off shotgun.
Judge, I object to any testimony about this at this point and would like to approach the bench.
Yes. At the bench, out of the hearing of the jury. Now, what was it you said? So he's not even paying attention.
No, he's
Anyways.
not.
He's starting to get into the gun.
I just said that right after he was arrested, a young boy found a shotgun.
It wasn't right after, it was several weeks, but besides that, it's just what we've been going over in chambers.
Well, I said you could talk about a gun.
I just said shotgun. I didn't say same shotgun. I mean, I preferenced it like that. If I'm wrong, then...
Overruled. You may proceed.
Sometime after Mr. Marlowe was arrested for the murder of Otis Abner, a young boy who lived there where Mr. Abner or where Mr. Brock was living, found a double-barrel shotgun, a sawed-off double-barrel shotgun, laying in a junk pile. He picked up the shotgun, brought it back to the house, and the testimony will show that an individual who was there at the house took the shotgun from him, and that the individual attempted to take the shotgun to Knoxville and dispose of it, Knoxville, Tennessee, and before it could be disposed of, Trooper McKnight regained custody of the gun. That's basically a brief overview, ladies and gentlemen, of what the testimony will show today. As in all cases, I'm sure that there will be more things to come out in this case, but I know that you'll listen to the testimony and the evidence that the Commonwealth will put on, and once you hear the facts, and once you listen to the testimony and see the evidence, that there will be no doubt in your minds that this defendant, Marlowe Brock, did in fact shoot Otis Randall Abner in the head and kill him on September the 10th, 1987. Thank you.
Okay, now we're getting ready to get into Mr. Robinson's open statements. Arctic makes a good point. It's one I've thought of a lot. And if Jean Crawford was close enough to get Otis's blood all over her, she has to know exactly who fired the shot, in my opinion. I agree, Arctic. If she was sitting there.
Right.
I mean, that's, in my mind, that's questionable. Another thing is she went to her son's house. She took a shower. Why did they not collect her clothes? Why did she not enjoy in the shower?
Yeah, I mean, I'd like to know if she did have clothes that had anything on them.
Right.
3 people on a cemetery. They all 3 should have been arrested, in my opinion.
Absolutely.
That's right.
Mr. Robinson, you may make a statement now, or you may reserve it until later, whichever you desire.
I'll make it at this time. Yes, sir.
Okay, Lori, I'm going to brace you for this one. This is going to aggravate you, and I love you, honey. Okay, you may proceed.
May it please the court, Mr. Bingham, members of the jury. This is really a case about somebody who didn't like Otis Abner. It's a case about somebody who didn't get along with Otis Abner, and a case about somebody who probably shot Otis Abner. The person who did this probably was Jeff Crawford. He's going to testify here today. On September 10th of last year, Marlowe Brock, well, let me start over. On September 10th of last year, Jeff Crawford and his mother, Jean, were both living with Otis Abner. Jean was dating Otis Abner. On September 10th of last year, Marlowe went to their house. He went to see Otis Abner, he'd bought a car from him, and they were going to trade some titles and paperwork to the car. When he got to the house, only Jeff was there. This was early in the morning on the 10th. At that time that Jeff and Marlowe got together, they went various places around Knox County. They even went to Clay County at one point. They were drinking quite a bit during this time. As they were driving around, at one point they came to a person that you heard Mr. Bingham refer to, a person by the name of Jess Smith. At that point, Jesse Smith did have a shotgun. Jesse Smith and Jeff were looking at the shotgun. The shotgun was even fired at one point, while they were there at Jesse Smith's place. Then Marlo and Jeff left and they went various other places. A lot of the details as to where they were gone, you'll hear testimony too. It's not important that I go into every specific place that they went to at this time, but just listen to it as it comes up. That evening, Jeff and Marlo ended up back at Otis Abner's house. The people that were there at the time were Jeff Crawford, Marlo Brock, Gene Crawford, and Otis Abner. When they got there, they ate. When they got there, they ate a little bit, and Jeff and Otis were talking about some marijuana that they could steal. Marlo had been drinking. Jeff had been drinking. Maybe just them. I'm not sure about Otis. Marlo was feeling a little queasy, a little sick from all the food he'd had and the beer that he'd been drinking all day. He went outside, was feeling bad. He got sick, crawled into his car, and passed out in his car. Next thing Marlo knows, Jeff Crawford had driven Marlo's car into a ditch. Marlo wakes up and realizes that Jeff Crawford had driven his car into a ditch. At that point, Marlo gets Jeff to move over. Marlo gets behind the wheel and starts driving. Gene Crawford was in the car also, in the back seat. The first Marlo heard of Otis Abner being killed was at that time. Jeff Crawford told him that Otis Abner had just been shot, and Marlo didn't believe it at first. But Jeff was persistent about it, told him again, and said, yeah, I mean it, he had been shot. Marlo took Jeff and Gene Crawford to Jeff's brother's house, Robert Crawford, and let them out. They stayed there for a while, and then Marlo went on home. Now you'll hear reasons here today why Jeff Crawford did this. Why is he saying this? Why is he the one that's trying to pin the blame on Marlo Brock? You need to listen for those reasons. Some of them are possibly that Otis Abner had at various times hurt Jeff's mother, Gene Crawford, had beaten her up. Various times over a period of, I know, at least a year. Another reason possibly could be that Otis Abner, the person that was shot in this case, at one point cut Jeff Crawford real severely with a knife. Enough so that Otis Abner was convicted of a felony because of it, a felony assault. There may be other reasons that come up. You need to listen for them. I'm not sure right now what all the testimony is going to be. All I can be sure of is that Jeff Crawford saw his chance here. He knew he wanted to get rid of Otis Abner. He wanted to find a way to do it, so obviously he didn't go to jail. He didn't want to go to jail, just like anyone else. He saw his opportunity. He had his reasons for doing it, and apparently he did. Now, Jeff's mother told various stories the night this happened. First of all, she said that only herself and Otis Abner went to the cemetery. She was trying to protect Jeff. She didn't want her son involved in it. So listen to her testimony here today, too. Listen to how her
Can you see it, Allie, or do you want me to try it?
listen to how her testimony changed after the police tried to pin her down a little bit more. If you do, I think you'll see that Marlo Brock is not the one that should be on trial here today. But unfortunately, he's the one that is. Jeff Crawford is the one that should be on trial. If you'll listen, I think you'll see that Marlo Brock is not guilty of this charge. Thank you.
Okay, and that is the end of the opening statements. Again, so far, everything that I've saw, the Commonwealth failed. They failed my uncle. They failed his family. 3 people on that cemetery, all 3 of them should have been arrested. You
Or
don't
at least
take the
taken into
word
custody.
of exactly. I mean, you just don't take, what's a better way to put this and how I want to. Anyways, you don't just take the words of I don't know a better word to say it. A
Well,
felons.
when you have a mother and son and another man, why would you take the word of the mother and son instead of this other man's word? Because
Exactly.
obviously they're going to take up for one another.
That's right.
So all 3 should have
And
been
you-
taken in for questioning and separated and questioned.
And they should have took the evidence from Jean. I mean,
Yes.
if she had evidence on her, then her clothes should have been collected. They should have been sent off for analysis. None of that happened in this case.
Because the crime lab should have been able to tell if it was, well, which side she was on. Was she in the car or was it
Right.
blowback?
Right, exactly. Well, that to me is one reason they didn't ask for her clothes.
Yeah.
Yeah.
Well, and none of this to me, and I'm sorry, y'all. It irritates me, but it don't feel like anything was done right. Even looking at the motions before trial started, you've got one of the witnesses right back there in the jury box, or in the judge's chamber, going over evidence. And I understand, yeah, he was a Kentucky State Trooper, but I also understand that he was the very trooper that they called. And I think Lori is correct. I think that he was lured there. I think all 3 of them knew what was going to happen. I think it was premeditated, in my opinion.
Yeah.
And
Because
yeah,
I don't
think
see Marlo Brock being in the car, not being awoke by the gunshot just when the car hits a ditch.
Right, exactly.
well, let's think logical, okay? In Jean's statement, she acted like that when she heard the shots, she thought because they were there to steal marijuana, and my uncle was no thief, but that they were there to steal marijuana, that whoever owned that patch was the one doing the shooting. First of all, why are you going to crawl toward the shot? I'm going to hunker down in a floorboard.
Well, yeah, if I can't get the door open, I'm not going to be trying to make myself more visible by going over the seat.
Absolutely not. And then she says she crawled out the window, but the officer said that all the windows was up. So
Which is it?
that don't make no sense. Said all the windows was up except for the driver's window. So what you do? Roll the window back up?
Right.
I mean, it makes no sense to me. None.
And why
And
would
there
they
is
think the
one more
shoes being
thing.
there? The shoes being there doesn't mean she's there. I mean, she's going to leave without her shoes on.
Right.
There is one more thing that I do want to show. Absolutely. I think it needs to be. So give me just a second. Because this has aggravated me to no end ever since that I read it. And that's this right here. It's redacted, but it says Jeff stated that he didn't remember it and he had lost his lighter previously. At this time, Jean spoke up and stated she removed the half case from the Abner vehicle. She stated after Ball was shot, she got her purse and the Budweiser half case out of the passenger's floorboard of Abner's vehicle. She stated the half case contained 2 beers and she thought she might drink them to calm her nerves after the shooting. I asked her after witnessing her lover shot, how could she think of her purse and 2 beers before exiting the vehicle? And she stated she just did.
But not her shoes.
Yeah.
She was worried about her purse and the beer, but not her shoes.
Let me grab my purse and the beer, but I'm going to leave my shoes here.
Yeah, I'm going to go barefoot on this gravel road here.
It makes no sense to me. She grabs her purse and she grabs her beer, but she's so tore up that she leaves her shoes. In the words of my daddy, that dog don't hunt. It makes no sense whatsoever.
Well,
now you
Brianna
think
just
about
made a
her
good
previous
point.
statement. If Jeff did the shooting, a second.
How did he avoid
How did
blowback?
he
The
avoid?
sawed-off would have been a larger spray paint. Maybe Jean wasn't the only one who took a shower, or maybe she wasn't the one who took a shower.
That's right.
Well, other testimonies will show later on when we get into those that he did have blood on him.
Mm-hmm. Yes.
Why wasn't all of their clothes took? But now let's think back to her statement that she thought that whoever's pot patch that was who was doing the shooting. That's what's running through her mind. She's crawling toward where the shots are coming from, but she grabs her purse and her beer.
Yeah.
I want to know how she's crawling with that.
Yeah.
She had to
I'd
set
be
that
running
over
away.
the seat first. She
Exactly.
had to set all that over the seat and then crawl over the seat.
Mm-hmm.
It don't make no sense. Makes no sense whatsoever.
Well,
Why
aren't your
didn't the
thoughts so
officer
too?
request her clothes? But Lori, that is the question of the day. Why didn't the officer request her clothes? Why didn't he request all of their clothes? Why was it, what, Lori, 2 weeks later, 15 days later, something like that, that they test Marlowe's hands for gunpowder residue? Why didn't they test all of them? I'm telling you, that's where that story of Jesse, them getting the gun at Jesse's and all of them were shooting comes in at, because they thought, well, if we get our hands tested, then we can all test positive for gunpowder residue because we're done saying that we shot a gun at this residence.
Yeah, they
That's
shot the
my
gun. She
opinion.
took
But it makes more sense than
shower.
any of this garbage.
Yeah. And Rhiannon says, would he have had his mom in the potential line of fire? Well, if she was in the car.
If she was in the car. I mean, but what proof
Exactly.
do we really have?
We
I
don't.
left shoes in a car before. What
Me
proof
too.
do we
She
have?
was in that car a
She was
lot.
in the car.
That's right.
Yeah. I'm sorry, my mind's working in rapid fire. Don't feel obligated to answer. I will not be upset. Oh no, you're fine. I mean, you're asking questions that
Yeah, then that's a good question.
Are good questions. The fact is, though, Commonwealth They did not do my uncle justice. My uncle did not get justice. Now, in this first case, like I said, yeah, that's a big F, Lori. That's a big
Right.
F. Because I don't think her hind end was in that vehicle, in my personal opinion. I
Nope,
have
I
no
don't either.
facts to back that up, but that's this little country hillbilly redneck girl's opinion. 4 hours is normal half-life for GSR. Like I said, they should have all immediately been taken in and tested for GSR, and all their clothes should have been collected as evidence. I agree, Arctic. Hey, Kim, there you are. They all would have been dead if it was. Yeah.
Yeah, Kim.
Yeah.
Absolutely.
You're right, Kim. If it would have been anybody else, that to me, that is just a story that they told. It's a story they told.
Mm-hmm.
Because a
They
double
wasn't
barrel
there.
shotgun, you can shoot twice with it before you have to reload, correct? So why wouldn't they just shot her too?
Girl,
That's right.
Cherokee girl, you still in here? You are a gun expert, girl. Hey, Arctic. I don't know, honey. I don't know what happened. I was thinking, now she's a mod. There shouldn't be no reason that she's blocked. But to me, another thing, there's 3 photos that was allowed into evidence. There's 59 photos.
Mm-hmm.
Yep.
Hey,
59.
Cherokee girl. I mean, 59 photos. They allow what? 3.
Yeah.
Yeah, 3.
And
Mhm.
I'm wondering, what are those 3? They make a big deal out of her shoes being in the floorboard. Well, guess what? I got shoes in the floorboard out there right now in my vehicle.
Cherokee, it was a double barrel.
And I've still got the question that I had from the get-go on this. Where was my uncle's? Where was his gun?
That's right.
I think they lured him up there. I think
Well,
it
I
was
agree.
premeditated. And they knew what, I think it was planned.
Yep.
That's my opinion on it. And I think they rushed this trial, not just this one, but the one that followed as well. They didn't do their homework on it. During the grand jury, they openly admit they're still investigating.
Yes. And not only that, they did 2 trials within a year.
I think it ended up being almost 2, didn't it, Michelle, when we started looking at or maybe it was me and Lori looking at the dates, one of the 2 of us. But still, it was a short time. It surpasses a speedy trial.
Mm-hmm.
Well,
Her shoes being in the floorboard of that car doesn't prove she was in the car. I completely agree, Lori. I completely
it
agree.
happened September 10th, and the first trial was June, was that 14th?
Yes. Mm-hmm.
The following year.
Right.
But during the grand jury, they're still talking about they need to do this and need to do that in their investigation. That should have been done first before they went any farther.
Right.
And it doesn't sound like it was ever done because it's never brought into the trial.
Sorry, I was using talk to text, and it does like my country accent. That's okay.
It never likes me.
A lot of us have a country accent. It can't
It
never
thinks I'm talking
understand
about
me.
aliens. I always
Could
think
you
I'm talking about
imagine?
aliens.
Could you imagine if they'd said they weren't going to allow crime scene photos into evidence in the OJ trial? Someone knew someone important for this investigation and trial to be. That's the comment of the day, right there.
Yes,
Yep.
it is, Arctic. You are right.
You think it goes beyond those three, Lori?
She thinks 100% Arctic. Yeah. Yeah, I think it goes further than those three too. I mean, there was a gray vehicle witness. Yep, right here. A witness that lived at the end of the road said he saw a gray car leaving from there. The defendant stated one of the women's sons owns a gray car. That's absolutely correct. In my opinion, if she was in that car, her ears would have been ringing. The pressure of her ears would have been unbearable. She wasn't in that car, in my opinion.
Would that be the son of Jean's house that they went to? Where the gray car could have came from?
I'll give you my opinion on it. I think there's more than one son that's involved. That's my personal opinion.
Right.
That I don't want to get into speculation, but
Well, right. I just wondered why they went to her other son's house.
yeah,
Right.
why did they do a lot of things that they did that day? And I'd be curious to know what photos they did allow into evidence. Like I said, there's 59. What was it? The photo of the bullet? Was it just of the shoes?
I'd like to know that too. Because I'd like to know why they think 3 photos is going to be enough to depict the scene.
Well, Kim, normal people would have.
They would have.
You know, unless, in my personal opinion, they were gathering up to make a story up.
So say they had to get their story straight.
Notice who leaves first.
Marlo.
I will say this. I went my whole entire life thinking Marlo Brock was guilty of this. After looking at these, I'm not so convinced. Do I think he was involved? Absolutely. In my opinion. Do I think he was the trigger man? I'm not convinced yet. I'll have to see the rest of it, but so far, no, I'm not convinced.
Me either.
I completely agree, Duchess.
Yes.
Wasn't
I
handled
wonder,
right.
since Marlo left first, I wonder if they were trying to get their story straight. And when he left, they decided to set Marlo up.
Well, that could be for sure.
Well, I mean, see, there's so many possibilities. But you answer me this. How is there 3 people on a cemetery and nobody sees who pulls the trigger?
Well, exactly.
Yeah, with this trial, Arctic, you're right. I am And I'm sorry, I'm still stuck on the fact that McKnight was back there in the judge's chambers. Lori, did you know that before today?
Kim, that could be true.
Maybe that's why he was sick and threw up. Does he know what they were going to do? Just a thought.
That's a good
I
point.
can tell you this. These people weren't smart enough to pull this off. They had help. I agree. I agree.
Well, since they called Trooper McKnight and not just the police, I have to wonder about him.
Yeah.
Who knew him well
Yep.
enough to have his phone number just to call him?
Right.
And what would he have done? I'm just saying.
Because, and what was the reason, Michelle? Again, remind us of why they said they called him.
Because he was a good guy.
Let me see here. Oh no, Kim, no. That ain't why he throwed up. I got a feeling he wasn't no throwing up to it. Just a second. But there is a lot more documents. We haven't even got into the testimony. You will hear them mess up their own testimony.
Yes.
Trust me, you will.
Mm-hmm.
I just, like I've said before, at the very least, the world deserves to know my uncle did not get justice. That my cousin, Lori, her brothers, they didn't get justice for their dad. He has grandkids that he never got to see. And regardless, nobody deserves to be murdered like that. My uncle treated me with kindness. If you didn't mess with him, he wouldn't mess with you. That's the way I saw him. I can only speak as I knew him. And he was always good to me. I've got very fond memories. And justice deserves to be served.
Yes.
The world deserves to know that there was a man named Otis Randall Abner, and that he had a family that loved him. And Knox County, Kentucky, Commonwealth, let him down. At one point, we noticed today that Mr. Robinson calls himself Commonwealth.
Yes.
Didn't we, ladies? Makes
Yes,
me
we did.
wonder, did he ever work for them? Is this a scratch my back, I'll scratch yours? Exactly. We have no closure, Lori says. It's hard to move on from that. And the anniversary is coming up. Another year without answers.
Like Lori says, no closure.
It's already.
For family.
Exactly. Yep. Exactly, Duchess. Georgia, we're talking about my uncle's case. Otis Randall Abner. He was murdered in Knox County, Kentucky on September the 10th, 1987. Estimated time was around 11:45, and nobody has done time for his murder. If you all don't care, because Lori knows and I know how bad this went in the past, but I want her to know that we support her here on Coldcasecrystal. Put some hearts in the chat. Let her know you're thinking about her. I think she's going to be on here to tell her truth. Like I said, I'll never put anything on my channel that would disrespect my family in any way. So if at any point she calls me and says, don't say this, don't do that, I will absolutely do that. I will absolutely listen to what she says, because that's what's important. I appreciate you, Lori. I love you, sis. And if you all think I can sing, that right there sure can. Just
Boy,
saying.
ain't she? My goodness, that girl can sing.
Michelle, thank you, Lori.
Yeah, she can. She's got a good voice. It's beautiful.
Yes.
And I want to thank Michelle and Allie and everybody that has helped me with getting these files. Michelle has worked hard at getting files and doing FOIAs, and we've worked her tail off to get these. And once again, so people know just how corrupt this town is, Michelle, would you care to tell them just one more time what we had to go through to get these files?
I submitted several requests. I called the clerk's office. They told me I had to talk to Mr. Helton to ask for those records, because the woman didn't even know what a FOIA was. In the clerk's office, didn't know what a FOIA was. I finally got in touch with a lady in the clerk's office named Lily, sorry. And Lily told me that those records would be in the archives, gave me the location where they were supposed to be in the archives, and I submitted a FOIA to them. I got a email back from them saying that in March of 2011, they were sent back to the local court. So I called Lily back and told her they were supposed to be there. So she says, oh, well, hang on, I'll go look. She's gone for about 10, 15 minutes and comes back and says, I don't have them. They're not here. And I said, well, it looks like instead of covering this case, I'm going to have to cover the corruption in Kentucky, and I'll try to keep your name out of it. She puts me on hold again, and in about 7, 8 minutes comes back and says, oh, I've got them right here in my hand. They were here. And I definitely believe, though, before Crystal got down there, that they took some stuff out.
I agree.
But they had those records.
Dutch, if there's anybody being disrespectful in my chat,
they had those
delete
records.
them and block them. I will warn you all. This is a very serious case to me. And if you disrespected my chat, you will not be in it again. I guarantee you. You'll have one comment and that's it. This is not baseball. It is not 3 strikes, you're out. Don't
Cherokee
like
Girl,
it.
they had both been drinking.
Yes, they
Cherokee
have
Girl,
both
they
been
had
drinking.
been driving around all day long looking for $1 here, $1 there, and beer.
Yeah. Yeah, they have both been drinking all day long. Ran out of gas, said they spent the whole day just pretty much looking to bum money or find beer, according to Jeff. That's his statement. But I do appreciate you all. Thank you for being here. And Lori is right. You should hear her daughters. They can sing also. I appreciate you, Lori, for being in here. And like I said, Lori will be telling her truth, if she so desires. But I'd appreciate it if you guys would share this out. That way we can get it in the algorithm, because justice deserves to be heard. Everybody deserves to know that there was corruption in these cases. There is 2 trials here. And the more we get into it, the more corruption you will see. I love y'all. Remember, it takes 0 effort to be a good human being. And again, thank you for being here. Until next time.
I know you told your friend you're not okay, and tell me what's wrong and why you never said you felt that way. And guess you're trying to stay strong and fake a smile until I look away. But I've known you too long, it hurts to watch your blue eyes fade to gray as you fade away, as you fade away.
Yeah, I'm about to fade away, cause every time I wake up I feel like it's Monday. Something's going wrong with all the chemicals up in my brain. All of a sudden I don't look at anything the same way. Got a buildup of my thoughts sitting in an ashtray. I'm sorry that I'm so inconvenient, okay. Just let me be me and I'll stay out of your way. I can see the way you look at me, I'm such a disgrace. I never really asked to be brought into this place. You wanna love me? Well then baby I have a taste. All the highs and the lows, no, you'll never be the same. I don't really wanna hurt you, but I can't control the pain. If you're sticking by my side, maybe we could be okay. Okay, maybe you could be the change I need today. I promise that I've never felt this way. I really hope that you will choose to stay through all the pain.
I know you told your friend you're not okay, and tell me what's wrong and why you never said you felt that way. Guess you're trying to stay strong and fake a smile until I look away. But I've known you too long, it hurts to watch your blue eyes fade to gray as you fade away.